Good afternoon. Welcome to this week's episode of the Martinez Love Legal Lounge. My name is Kristen Martinez. I am one of the owners of Martinez Love, and I host these weekly Legal Lounge episodes every single Monday right here on Facebook Live at 12 o'clock. As a way just to provide an informal, no pressure forum for the community, for real estate professionals to ask their legal questions. Later on in the episode, I will be answering those questions live. So if you do have questions, please make sure to go ahead and put them into the comments, and I will be sure to address those in just a few minutes. I also get questions submitted to me from you all throughout the week, and I do save those, so I have two of those to address for you today. But if you are joining us this afternoon and you do have questions, please go ahead and put those in the comments, and I would be happy to address those as well. Also, if you are joining us this afternoon, go ahead and say hello in the comments. I would love to acknowledge you and thank you for being here. So make sure to do that as well. Just a tiny bit about me. I've been a real estate attorney for a little over 10 years now. I founded what was Martinez Law, we are now Martinez Love, back in 2015 as a full-service real estate law firm. That is what we are experts in, real estate law. That's what we practice. That's what we've practiced since day one, and that is what we have chosen to specialize in as our niche since the very beginning. We don't practice any other type of law. We do some areas that are related to real estate, such as HOA and condo association law, but that is all that we do. And so we are the experts in that area, and we are here for you as you have questions or you have different needs arise. But one of the goals that I had when I started the law firm was to help to educate the public, the community, and the real estate profession about some legal issues and pitfalls that could get them into trouble. A lot of the litigation matters that I handle could have been prevented had the parties been better educated, had they understood the contract that they were signing, had they known what the consequences were of not following the contract or following the law. And so this is one way that I'm able to help educate you all in the real estate community to hopefully avoid some of those issues down the road. So please utilize this. Send me questions throughout the week. Comment with your questions below, and I would be happy to answer those for you. A couple of quick announcements before I jump into the questions. I announced this on Facebook and Instagram last week, but we as a law firm are now on TikTok. So that has been definitely an interesting and a fun development for us as we kind of figure that out and navigate through those waters. So please go ahead and join us. Martinez Love Law is our handle for TikTok, and please go ahead and join us for some exclusive content there. As you all probably already know, we are moving hopefully next month, so we will keep you updated on our social media as that renovation project progresses, and then of course when we finally do move. Also be on the lookout for a grand opening celebration we will be planning in the future once we are moved and settled in. Lastly, we are gearing up for our next monthly event, Get Real with Attorney Martinez. That is a monthly event that I do. It is going to be on the first Wednesday of every single month at 10:30 a.m. Our next event is scheduled for September 1st at 10:30. We do have both a Zoom and an in-person option for that. So I would love to see you all in person, but of course I do understand there are many reasons why you would maybe prefer to attend by Zoom, so we are offering that option as well. But the topic for the September 1st event is going to be deconstructing the Florida Land Trust. If you've followed me for a while, you know that I am a huge proponent of utilizing land trusts if you are an investor or for basically holding title to any property aside from your primary residence. So if you would like to hear why, if you would like to learn about the ins and outs of how the land trusts work, that would be a great event for you. You could simply send me an email or just DM us for the link to register for that, or you could go ahead and search for the link or for the event on Eventbrite, and you can register directly there. So once again, I would like to thank all of you who are joining us. Again, please make sure to say hello in the comments. As you have questions, please go ahead and put those in the comments as well, and I will make sure to address those. But I'm going to go ahead and jump in and start with two questions that were sent to me throughout the week last week. The first one is from an agent that I work with, and her question is, what is the approximate cost to have a residential purchase contract reviewed? So again, if you've heard me speak before, if you've followed me for any period of time, you know that I believe it is very important to have all contracts reviewed by an attorney. Yes, we have a standard contract. Yes, it's used all the time. Yes, it could be described as self-explanatory as far as filling in that contract appropriately. However, there are so many lawsuits and disputes that could have been prevented had the parties had an airtight contract, had the parties understood what was in the contract, and had the parties done their due diligence prior to signing it. So I am going to take this question to again drive home my point that it is so important to have all of your clients, buyers and sellers, have their contract reviewed by an attorney, get their questions answered, and get advice from that attorney. An attorney is going to make sure that the contract is drafted in a way that their client is protected to the biggest extent possible. Whether that means, number one, making sure the contract is completely and accurately and appropriately filled out. But number two, recommending if there are any addenda that would be applicable to the transaction that may not be included. I have yet to review a contract where I don't have some change or some tweak or some addenda to strengthen the contract and make it even more airtight. I've never had a perfect contract that I've had no changes or advice on, and so that's extremely important. Also, it is extremely important that the client understand what they're signing. The contract has a lot of language and terms that an everyday home buyer and seller is probably not going to understand, or not understand it to the extent that they need to make sure that they're protected. As a real estate agent, you can't give that legal advice. You can't interpret the contract for them. That's why they need an attorney to review it. And so we need to make sure that our clients are reading the contracts. That's step one, which that doesn't always happen, believe it or not. But number two, we need to make sure that they are understanding the contract, they're understanding what their obligations under the contract are, as well as the consequences for not fulfilling those obligations. So now that I've given my unsolicited advice on why you need a contract reviewed, let's talk about cost. So at least with my firm, we bill everything on a flat fee basis. So if a client comes into our office or is referred to our office, they tell us what they need, we will get back to them with a flat fee, guaranteed fee for that service, and then the client can decide whether they would like to move forward or not. Contract review in my firm comes with a free 15-minute consultation if needed. A lot of times the consultation isn't needed because I'm going to recommend that you get the contract review, but that is there if it is needed. And then as far as the fees go, I'm going to give you a range because transactions obviously are going to differ as far as complexity and things like that. But for if we're talking about the standard, one of the standard FAR/BAR contracts or CRISP contracts, you're looking at a range between $250 and $750. And where you fall in that range is going to depend on, again, the complexity of the transaction. It's going to depend on what kind of shape is the contract in. Is this a for sale by owner where the contract is a hot mess and it needs a lot of work? Is this, is there something unique within the transaction that is going to require a customized addendum for that transaction? That's going to put you into the higher fee range. But if you have a solid contract, it's filled out appropriately, it's a standard run-of-the-mill transaction, you're looking at that $250 range. So While I understand when you're buying or selling a house, you want to spend as little money as possible, and I get it. But it's going to be in the thousands, probably many thousands, for me to clean up a mess that could have been prevented had the contract been done appropriately and been understood by the clients to begin with. So I do think that, a few $100s up front is well worth the potential disaster you can avoid down the road if it comes to that. So thank you for submitting that question. Hopefully that helped. If you have any follow-up questions or anything else on that topic, let me know. Additionally, as you have other questions, go ahead and put those in the comments for me, and I would be happy to address those. With that, I'm going to move on to the second question that I received actually this morning, shortly before starting today's episode. And that is, if I win my case, does the other side have to pay my attorney's fees? And I'm going to start by giving you the typical attorney answer, which is it depends. And I'm giving you that answer because it does in fact depend. The first way that we answer that question is there either a statute or a contract that says you get your attorney's fees if you win your case? If you don't have one of those two things, you do not get your attorney's fees. So there either has to be a relevant or applicable statute, or in the contract that you're fighting over, it has to state that the prevailing party or the winning party gets their fees paid by the losing party. I will tell you that for the FAR bar contracts, whether it's the standard or the as-is, there is an attorney's fees provision. So any sort of dispute over a FAR bar contract, the winning party gets their attorney's fees paid. I will also tell you in most eviction or lease dispute type cases, you will get your fees paid as well. Most leases include a provision in the lease itself, but if not, the Florida statutes that govern the relationship between landlords and tenants do provide for prevailing party attorney's fees, which is what we call it when the winning party gets their attorney's fees paid by the losing party. So for most causes of action or most claims that you would have related to a real estate purchase or lease, you do get your attorney's fees paid. In other instances, you don't. So things like fraud or negligence, you would not get your attorney's fees paid. Partition actions, there is a statute that provides for attorney's fees, but those fees are taken out of the proceeds of the sale once the property is sold. So if you have specific questions about what type of case you have and whether you would get attorney's fees in those situations, let me know. I'd be happy to answer them, but that is my general answer for you. So thank you for that question. Karina, thank you so much for joining us. She's asking whether I do new construction. I'm assuming that means, do I review new construction contracts? The answer is yes, and I am even more passionate about making sure that your clients are getting those new construction contracts reviewed than if we're talking about a standard FAR bar contract or CRISP contract. New construction contracts are typically, they're a lot less standard, they're a lot longer, and they're typically very builder friendly, which means that the goal of those contracts is not to protect the buyer. So there are certain things within those contracts that we can negotiate and tighten up, but I will be candid with you, in this market, very few builders are willing to negotiate when it comes to the legal terms within the contract. And what I mean by that is, price, upgrades, premium lots, things like that are always negotiable. But when we're talking about, default provisions and, different legal aspects of the contract, their position lately at least has been, we're so busy, we have so many people wanting us to build them homes, you can sign this or not, we really don't care. So the big thing with those is making sure the client understands what they're signing and they're comfortable with signing it. One of the biggest complaints that I get with new construction is, they quoted me 8 months and it's been a year and my house isn't done, I want to sue them. Well, in almost all new construction contracts, it gives the builder a minimum of 2 years to complete the home. That's not highlighted in any way or pointed out by the builder, I'm sure, but that is one thing that we would go over to make sure that the client is comfortable with that. So I absolutely do review those contracts. I highly recommend that we get those reviewed. Thank you so much for the question and for joining us today. So I'll just go ahead and give one last call for any other questions. In the meantime, if you would please like and share this video, I would greatly appreciate it. If you've missed any portion of today's episode or any previous episodes, we do repost them on our YouTube page, so make sure to check that out. We've got quite a nice library of content there for you, so as you have questions or you want to hear me speak on certain topics, make sure to check that out as well. Not seeing any other questions, I want to again thank you all for attending today. We will be right here next Monday, same time, same place, here on Facebook Live for the next episode of the Martinez Love Legal Lounge. In the meantime, I hope you have a great Monday and a great week. I will see you next Monday.